Hello, and welcome to part 2 of our second talk on digital health, this time looking at AI data and some of the wider IP considerations. My name is Jack Severs. I'm a UK and European patent attorney at Gill Jennings Every. GJE are a specialist IP law firm with our main office here in London, and we advise a wide range of clients across patents, trademarks, and design rights. I lead GJE's medtech sector group, and so a significant part of my time is spent advising health tech companies on how best to protect their innovation. Today, we're joined by Ben Williams, an experienced solicitor advocate at Withers Tech, the specialist technology arm of Withers Worldwide, full-service global law firm. Withers Tech specialise in advising high-growth companies across a range of industries, including health tech and AI. So this talk covers some of the questions that arise most frequently in our work with health tech companies. In the first part, Ben covered how to ensure you have the correct contractual rights to use patient data as needed within your specific business model, and how to ensure that you can improve your AI system using that patient data. In this part, we'll cover how you can protect your technology and ensure you own improvements derived from data that you don't own, as well as finally looking at liability for incorrect decisions made by your AI system. So thanks again, Ben, joining us, and I'll hand over to you to recap what we'll be discussing in the second part of the talk.
Yeah, thanks, Jack. So in this part 2 then, we will be looking at the process and the output on this slide by reference to questions like, how can you protect your artificial intelligence software? Who owns the analysis and improvements which are derived from data that you don't own? Really key question. And then we'll move on to the liability systems for artificial intelligence and explore some of the issues there. But I just want to start then with the protection of software. And when we think about software, there are various different components which form part of the overall package. So you've got things like the underlying source code, the algorithms that make the decisions, the machine learning technology that underpins the entire thing, and the user interface and user experience. All of those things combined together are what we call the software platform, and there are various different intellectual property rights which are available for the protection of each one of those components. For instance, there's a number of different intellectual property and proprietary rights which are listed here, and the arrows in blue indicate that these rights subsist automatically. So that means there's no registration requirement, and just by creating the software, certain intellectual property rights may well exist. In addition to that, we have rights shown with a red arrow where application and registration is required to get protection. But the key point from my perspective to make here is that before you even think about which intellectual property rights are protecting your software platform, you need to make sure that you actually own the rights that you think you do. And the practical advice here, the tip is to make sure that everyone who has been involved in the software creation has signed an intellectual property assignment agreement. So that could be the founders themselves, all consultants, any advisors that you have. We often see that with digital health companies that have a medical or doctor on their advisory board who perhaps don't develop the software themselves, but still come up with concepts and ideas and documents around how that should look. And of course, with any external developers that are actually writing the source code and developing the software platform. And once you've got that intellectual property assignment in place, you can then feel fairly confident that you own all of the intellectual property rights. That will then give you the intellectual property rights that are shown in blue there, and the ability to make any applications shown by the red arrow, including patent applications, which, Jack, do you want to come in on that one?
Yes, thanks, Ben. I think it's worth quickly mentioning that our first talk on digital health focused on how to identify whether your technology is patentable and assessing the value that patent protection would bring to your specific business and technology. And you can find that talk on our YouTube channel, and that goes into a lot more detail. But to briefly recap what we covered in that talk, ultimately, like any other technology, digital technologies must meet the fundamental requirements for patentability. So they must be new, so that's have at least one new feature over the closest known technology. They must be inventive, so those new features must solve a problem in an arguably non-obvious way, and they must be technical. So the problem solved must fall within a field which is not excluded from patentability by the Patent Office. Now, although actually pure algorithms and machine learning models are considered mathematical methods by the Patent Office, and that is actually a category which is excluded from patent protection. But actually, in practice, if they are linked to a particular application, a technical application, such as one in healthcare, they are very likely to be considered patentable. And in fact, we routinely file patent applications for machine learning based healthcare technology. So I'd say that the main difficulties really arise for this type of subject matter when you try to claim a particular model too broadly. So, for example, if you're trying to claim a generic model applied to any kind of abstract or undefined data, that will be considered a mathematical method and therefore not capable of patent protection. But if you link the application, so if you link to a specific healthcare application by defining the type of data used to train the model, specifying how the model is applied to solve a particular problem, for example, in diagnosing a particular condition, then there's a clear link to a real-world technical application, and the algorithm or model will likely be considered patentable, assuming, of course, that it is novel and inventive. And as I mentioned in the last talk, the EPO actually looks very favourably on health-related applications of machine learning. In their guidelines to examination, they set out a number of clear examples which are considered patentable. And so if your technology has any parallels with these, then they will very likely be considered technical. So one example set out in the guidelines for examination is the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats. Although that's quite specific, what that actually means is that any type of machine learning model applied to monitor or identify a particular physiological parameter which has parallels with that example will be considered patentable. And actually, the EPO go even broader than that with another example, which states that the classification of digital images, video, audio, or speech signals based on low-level features is something that is considered technical, and so will overcome that excluded subject matter category. So it's possible to protect a particular model which has been developed for a particular application. It's possible to protect a method of using that model, for example, to diagnose a particular condition. It's also possible to protect a method of training a machine learning model. For example, if you've created a new training protocol which causes the model to learn particularly useful data representations for a certain classification task, for example, that again would be considered technical and potentially patentable subject matter by the Patent Office. So that really covers the AI and machine learning side of it, but I thought it's also worth saying a few words on user interfaces as they're on the slide there. So user interfaces are protectable by registered design rights, but it may not be as clear to some of you that they're also protectable by patents. So in particular, any features that provide a particular function rather than being solely aesthetic could be protectable by a patent. What the guidelines say on this is that actually it's much more straightforward to protect features which relate to user input rather than display features. I mentioned in the last talk on digital health that features which relate solely to the way information is presented will not be considered technical. So it's much more straightforward to protect features which enable user input. The EPO gives examples such as entering text, making a selection, or submitting a command as features that are normally considered to make a technical contribution. So it's worth bearing in mind that if you have any particularly innovative aspects of your user interface, that these two might be considered patentable, and so you could get the broader protection possible via patent protection. So to conclude, there's certainly a number of aspects of these kinds of technology platforms which are considered patentable. However, as Ben has mentioned, that's all well and good, but it is crucial to have the correct contractual provisions in place so that you can actually use the data in the way you need to in order to train the model. And of course, another related issue that I think Ben's going to touch on next is ensuring that you own the developments based on that data so that you are actually entitled to any patent application filed. So I'll hand back to Ben to tell us a bit more on that subject.
Yeah, thanks, Jack. So let's just address that question then of who owns analysis and improvement from data that you don't own. So we're thinking about circumstances here where third-party data has been provided to you for the purposes probably of developing your artificial intelligence system. And from that, you've been able to do some clever form of analysis or improve the overall system, but that's all derived from data that you don't own. So what happens in those circumstances? Now, generally speaking, the rule is that any analysis or improvements that your team make in-house will generally be owned by your company. So that's a really helpful starting point. If the analysis, the improvement that has been done by a third party that you have contracted with, then it's likely that they will own those rights, and you will have to, as mentioned on the previous slide, make sure there's an intellectual property assignment in place so that ownership is transferred to you. But general rule, if you do it in-house, you will own it. However, there is an exception to that, and it is not uncommon at all for the contractual matrix, the documents that you enter into, for that to alter the standard position. It's not uncommon at all for those contracts, especially at an enterprise level, to reverse that position. And that's often subtly done through an overlapping series of different provisions in the agreement which address data generally. So the key point here really is that whenever entering into a contract with a third party to get hold of data in the first place, that data is being licensed to you, to make sure that all improvements and what's called derivative works are owned by your company and not by the counterparty, which is often the contractual starting point. If we now look at the output part of this slide, and in particular try to answer the question as to whether you are liable for incorrect decisions that are made by your artificial intelligence system. That's actually a really difficult question to answer, and it's highly dependent on your specific business. But what we've got on this slide is a model which, if you apply that to your business, might provide you with a useful guide as to what is likely to be appropriate. And that model really is based on the involvement of human end users. So the first one we would call a human in-the-loop system. That is where a recommendation driven by an artificial intelligence algorithm is made to the end user, but the end user is always in control as to whether they accept and act on that recommendation or whether they choose to ignore it and act on their own knowledge and experience. That's a human-in-the-loop system. Human over-the-loop system, this is number 2. This is where you have an artificial intelligence system which is making decisions. Those decisions are processed by a computer system until such point as the artificial intelligence system reaches an impasse or an unexpected scenario, at which point it's passed to the human end user, whose role is that of a monitor or supervisory capacity. And the third is a human out-of-the-loop system, where the artificial intelligence system is making all of the decisions by itself, and the human end user has no input whatsoever. If your system falls into the first one of these, the human-in-the-loop system, it is probably likely that liability for artificial intelligence-driven recommendations should be excluded, and that should be set out pretty clearly in all contracts that you enter with end users. The reason for that is because the artificial intelligence system is really just delivering a recommendation. It's nothing more, it's just a recommendation, and the human at all times remains in full control. So if the recommendation turns out to be wrong, it would be inappropriate for liability to rest with you. In a human over-the-loop scenario, that's slightly different, but liability which arises from a failure to adequately monitor on the human's part, that should be excluded. Again, because the human remains in ultimate control, and liability shouldn't rest with you where there has been a failure on the human's part to do their job properly. Again, that should be pretty clearly set out in all of the contracts that you enter. The third one of these, the human out-of-the-loop system, is more difficult and really does depend on the precise factual circumstances. But on the basis that no artificial intelligence system is ever going to be perfect, and a human out-of-the-loop system, because humans aren't involved at all, should only ever be deployed where the risks and probability of harm is low, there is a fairly strong argument that quite a lot of liability should be excluded. And again, that should be set out in the terms and conditions of the contract.
Thanks, Ben. So that concludes the second and final part of the talk on digital health, looking at AI-based technologies and the contractual rights required in order to use patient data in the way needed within your business and ensure you own any developments of your technology based on that data. If you haven't found it already, you can find the first part of this talk on GJE's YouTube channel. And if you'd like to find out more, there's lots of information available both on the GJE website and the WithersTech websites, and you can see the addresses listed there. Please also feel free to get in touch with myself or Ben via email, or you can connect with us on LinkedIn. We'd be happy to answer any follow-up questions or discuss your specific technology and business in more detail. Thanks again, Ben, and thanks for listening.